Okay. So we can start in the next minute or two. I've turned on the recording and
Okay. So what I'm going to do is I'm going to, hold on, let's wait for Vance. Oh, Vance, good. Okay. All right. Thank you, everybody, for joining us today. My name is Devon Lassine. I would just want to first welcome everybody. This is our first Business of the Art series, where we will be discussing music streaming in 2021. And I just want to make a few announcements first before we go ahead and get started. If everybody could, save the date for tomorrow, which will be January the 28th. CEH will be having our tele town hall where we will be announcing more dates that we will be having for our series and other tracks that will be specified for organizations. This one is a more individual-based workshop. And so can everybody do that? And if you want to sign up and register for that event tomorrow, go to dcarts.dc.gov. It'll be on our front page. And then just for other opportunities, the deadline for our facilities and building grants will be coming up on Friday, January the 29th. If you go to our website, we'll also be there and have that information up for you all to be able to sign up and access those grants. So with that being said, I just want to go ahead and give the microphone over really quickly to Vance, who is one of our partners in this series, so that he can go ahead and tell you a little bit about WALA, what they bring to the table, and what they have on. Vance.
Thank you, Devon. Good morning, everyone. Thank you for joining us today for this music streaming in 2021 education session in collaboration with the DC Commission on Arts and Humanities. I want to thank DCCAH. Thank you, Devon. Thank you, Patrick. And thank you, Jeffrey, as well. My name is Vance Levy. I am the Education Director for the Washington Area Lawyers for the Arts. And we call it WALA. And for those who don't know, I'm sure I got a lot of friends on here, but for those who don't know, WALA is a organization that's a partnership of attorneys and artists to deliver legal services and education services to, in our languages, to the DC area artists, creatives, and entrepreneurs. But of course, in this new reality that we live in, being online, our reach is even further now, so nationally and globally. So I want to thank everyone who's in on these sessions from around the world. Real quick, being the education director, I set up education sessions for the organization. Oh, I got to acknowledge our executive director on the line, John Good. What's up, John? How you doing, fam?
Hey, thanks for joining us.
And any other WALA volunteers that are here as well. I can't see everybody's name. But as education director, I set up education sessions for the organization. And I just want to really talk really quick about what we have going on past today. We are about to start the Creative Entrepreneur Series is what I want to tell you about. It starts this coming Monday, February the 1st. It's a 6-week, 6-part series that repeats on Mondays at 11 o'clock, except for on Monday, February 22nd. I'll tell you that. 6 weeks, 6-part series, every Wednesday. Monday, February 1st, we're doing copyright, trademark protection, and use. Very important for folks in this session because you'll be getting a brief overview about copyright. But the goal is to talk about music streaming. You need that overview before Brother Hardeep can get going into the music streaming. And so folks who aren't quite clear about copyright, I'm going to invite you to come to our copyright session this Monday, February the 1st at 11 a.m. If you're a WALA member, you can get the WALA ticket for free. If you're not, general admission, what I'm offering is a coded discount to get half off our general admission tickets. And that code is WALA, BOA 2021. I'm going to type it in the chat 2021, and then I'll also put the link to the session as well. Also, you can go to our website waladc.org/events, and you can get access to that tickets to that ticket for this Monday session there. February the 1st is copyright trademark. Monday, February the 8th is business entities formation. Let me get my cheat sheet out. Monday, February the 15th, we're doing tax strategies. February 22nd, contracts and licensing. March 1st, negotiation strategies. And March 15th, we're doing grants. That's the series. We got a lot of stuff going on. Plus, we have another session with BC Commission on the Arts and Humanities, specifically covering trademarks on February the 17th. But go to our website, email me. I'm going to put my information in the chat. Reach out to me, family. And without further ado, I'm going to kick it back over to Brother Devon. I tried to cover everything.
Thank you, sir. I appreciate that. We are on good time. Without further ado, I'm just going to go ahead for everybody and introduce our presenter. And I want to thank him for being here with us today and giving you all this information. Without further ado, Hardeep Grover is an attorney with Tresquire Solo Practice, where he focuses on helping startups and small businesses navigate legal hurdles. Hardeep began his practice immersed in the startup culture of San Francisco and developed expertise as a counsel to restaurants, theaters, and film production companies in New York. Having returned to shout out native Washingtonian, Hardeep now works with creative entrepreneurs in the technology, entertainment, and food and beverage industries. Just to save time, Hardeep received his BA in economics from George Mason University and his JD from the George Washington University Law School. And in his spare time, he enjoys playing with wild yeast fermentation, just a small tidbit. So without further ado, I'm going to go ahead and give the floor to our presenter, Hardeep Grover. Go ahead, sir.
If I could just jump in real quick. Hey, Hardeep, he got into the weeds on that bio, right? The other part I want to say is that, seriously, Hardeep is also a board member of the Washington Area Lawyers for the Arts. So please forgive me. I had to jump in there and get that in. So this is my boss one of my bosses on the line right here, ladies and gentlemen. You're going to enjoy this presentation. I'm sorry, fam. Hardeep, sorry for that Kanye moment.
Everyone, welcome to our session today on music streaming in 2021. I got to throw out a few disclaimers because I'm a lawyer and that's what we do. So the first disclaimer is I might be a lawyer, but I'm not your lawyer. So don't take anything I'm saying here as legal advice. I'm just trying to provide some information and help you out with, all of my background so that you can approach things in the best manner feasible. Another caveat on top of that is this industry is moving and changing on a daily basis. So I'm going to try and best here to kind of break things down for you, but just keep in mind that everything I tell you might be out of date by tomorrow or even by the end of this presentation. That's really how quickly things are moving in terms of licensing and changes, not in terms of the law specifically, but just in terms of how the industry is moving and how the industry is approaching things. So with that said, just a little breakdown on how things are going to go right now. We have a little under an hour left in the session, 51 minutes. And what I'm going to try and do first is give you a breakdown of the industry and how things work, how things are working, and how you should be aware of approaching streaming. After that, we'll open things up for questions and try and have a little bit of a discussion so I can help answer whatever, burning issues you have. So the first topic we're going to cover is how copyrights work in the music space specifically. Then we'll talk about what kind of royalties are relevant in the music space, and then how streaming royalties and how live streaming has been working since COVID began. And we'll touch on a variety of events that have occurred. Two specific ones will be D-Nice's Homeschool and BTS's Bang Bang Con, which have been very large and very different events that have led people to think that they can do certain things when maybe they can't. So with that, I first want to just touch on intellectual property and the different kinds there are, because there's a lot of confusion. A lot of people come to me saying, hey, I want to get this trademarked or get this patented. And, I just want everyone here to understand what kinds of intellectual property exist and what apply to the arts and entertainment. So there's three branches, let's call them, or legs of the stool, whatever you want, to intellectual property. And that's, of course, a big overgeneralization. The first one is trademarks. And trademarks exist to protect brands. Think McDonald's or Nike, protecting their name, protecting their logo, protecting their packaging and all of that. And while it's sometimes relevant for musicians, for the most part, trademarks aren't that big of a deal. And when it comes to live streaming, I'll touch on trademarks towards the end. But for the most part, if you're a musician, you don't really need to worry about trademarks that much. Next are patents. And patents cover novel inventions. Think the first iPod or the first iPhone. It covers all of the technology behind what's being created there so that people have an incentive to create. And again, for most artists, patents are really not an important function. And again, that's an overstatement because some artists really strive for the creation of products. But for music specifically, patents are not going to be relevant unless you're creating like a brand new type of mixer or something like that. So last, we're in copyrights, and copyrights protect works of authorship and artistic expression. And this is really the bread and butter for artists of all kinds. So this is the kind of intellectual property that you should strive to and expect to get. And it covers things like literature, paintings, and music. And so we're really going to be talking about copyrights today more than anything else. So what is a copyright? It's a legal right that gives a creator of an original work the exclusive right to decide how, where, and when it's used and by whom. And you get a copyright, and the requirement for copyright is that it be fixed in a tangible medium of expression. So if you have an idea for a screenplay and it's stuck in your head, that doesn't get a copyright. You have no protection on that. And if you tell someone else, still no protection. But if you write it down, whether you write down the concept of the screenplay or you write down the entire screenplay, you have protection. Same with music. Excuse me. As soon as you write the music down or record it, or even just hum it into your phone's voice recorder, it's fixed in a tangible medium of expression. And at that point, you have protection available to you on that work. So you don't need to worry about, hoarding it or not letting anyone experience it. Now, there are a variety of rights that come with copyrights, and those rights are the right to distribute the work, the right to reproduce the work, the right to publicly perform the work, the right to digitally transmit the work, the right to publicly display the work, and the right to derivative works. So distribution is, of course, just, spreading it out, selling it, whatever you want. Reproducing it is the right to make copies of it. So if I write a screenplay, excuse me, everyone, got some in my throat here. Reproducing it is just making copies. If it's a painting, it's making prints of that painting. If you've made a painting, that doesn't mean anyone else can go out and just make a copy of that painting and sell that painting. They have to have permission, and that permission comes from you as the creator of the original work. Public performance is playing it for the public, either commercially or not. Digital transmission, I think, is self-explanatory. Derivative works is basically secondary copies, secondary use. So, for example, if I write a book, I've got a copyright in that book, and I control that book, but I also control the right to make a movie about that book. Or let's say I've made a movie, I have the right to make a sequel to that movie with all the same characters and everything within it. So those are all the rights you get as a copyright holder. Now, a lot of people have a little bit of a misconception on what registration is and how it works. So if you, for example, submit something to the Screen Actors Guild, that doesn't create a copyright registration for you. If you put it in the mail and mail it to yourself, that also is not copyright registration. Some people refer to that as a poor man's registration. It's not real. There's nothing around that. Don't do that. It doesn't help you in any way. What really matters is whether you have the common law copyright or whether you've registered the work with the Copyright Office. So the moment you fix that work in a tangible medium of expression, as we discussed earlier, you get an automatic, instant, and immediate copyright in that work. You have protection, but there's not much you can do with it. It's really important to register each one of your works because you get special extra rights on top of it. First, you get a presumption of ownership with the Copyright Office, so it's kind of date stamped with them when they received it, so they know you created it as of this date. So if someone says, well, I made it in this later date, you have that presumption of ownership. You also have the ability to enforce your rights via a lawsuit, which you don't have without registration. So you can't sue unless you have that registration. The next are very, very important ones. They're statutory damages, fees, and costs of suit, like legal fees. And you want all of these because otherwise it's going to be very difficult to prove how much you are owed, and you're not going to be able to get all of that. You won't be able to get much recovery. So it costs you $35 to $55 to register your work, and it really makes a big difference in how you can enforce the lawsuit and whether you have to pay all of the fees of enforcing it. So I always suggest registering your copyright. So when you have copyright, you get all those rights I mentioned previously, and you also automatically become the publisher of your work. If there are multiple writers, you want to determine the split. Devon, my presentation's kind of moving around. Do you have any idea what's going on?
Sorry, I thought you wanted to go to, I thought you had forgotten to change the page.
No. I got it. No worries. Okay, so you automatically become the publisher, and if you have multiple writers, you have to determine the split, because just as a heads up, if multiple people contribute to a work, they're all presumed equal creators unless there's a writing to the contrary, an agreement to the contrary. So my example of this is if you are sitting on the metro and you're singing a song to yourself and something you're creating, and someone next to you just hears you and throws in a cool hook, and you decide to use that hook, they're technically 50% owners of that music unless you have a writing to the contrary. And this is much more helpful if you're proactively and purposefully working on something together, because it gives you the opportunity to say, okay, well, I put in 80% of the work, so 80% of this song is mine. You only put in 20%, so 20% is yours. Or if there's 5 different people, maybe all 5 do have equal ownership, or maybe they don't. Either way, you want to have that in writing, that split in writing, because otherwise the law presumes you're equal owners. As soon as you have a copyright, there's also potential royalties created: performance, mechanicals, and sync, each of which we'll talk about. So when it comes to music, as opposed to a regular visual arts work, there's actually 2 copyrights. There's the copyright to the underlying musical composition, what you have on paper, or what you have in your head. And then there's the master recording, the actual sound recording that you would hear on the radio or on Spotify or what have you. And they're 2 entirely separate copyrights and separate rights of ownership with separate royalties related to them. And the reason this exists, this framework exists, is because 50, 70 years ago, it was actually very rare that the songwriter and the artist singing or creating the work were the same people. Usually those functions were entirely separate. And today still, it is often quite separate, but you're just having this situation where a lot of artists are also the songwriters now. So they, in a sense, own or control or at least create both. But historically, there were separate functions, and so there were separate copyrights created for the 2 different concepts: the underlying musical composition and the master sound recording. So the underlying musical composition is music and lyrics, and it's usually owned by the songwriters. And the sound recording is the physical record of the musical performance that can be played back or reproduced. And it's usually owned by a record label or whoever paid for the studio time. Here's how copyrights work in publishing in terms of flow of finances and royalties. On the one hand, you've got the rights to the composition itself, which break down into performance royalties, which are collected by the performing rights organizations, and the mechanical royalties. And those are split between the writer and the publisher. And on the other hand, you've got sync rights, which is when when a audio work is synchronized to video. And we're going to talk a lot about this today because this is the basis of live streaming in a lot of ways. And what's important to know right now is that there's no compulsory or basic royalty here. It's all negotiated when it comes to sync and microsync. So this is all about publishing related to just the underlying musical composition. And this is for the sound recording, which is usually by the record label. We can break this into three different sections. There's performance rights, reproduction rights, and sync and microsync rights. And performance rights get broken down in interactive streaming or non-interactive plays, which is kind of like Spotify paid versus Spotify free, where you have the ability to control. The reproduction rights are generally handled by the labels. And on one side, you'll see everything gets paid to the record labels, performers, and musicians and background singers. And on the other side, it's collected by labels and just paid out to the performers and musicians and background singers in their shares. These days, these digital music distributors are really big players in the space, and they help independent artists and labels get their music to major online stores and streaming sites like iTunes, Spotify, Tidal, etc. They're very large players and have allowed this massive change in the industry of independence to come into play, whereby you can just put your music on Spotify. And it's created a flood in the industry, of course, but it really brings out a lot of opportunity. So moving on to royalties, there's three primary types of royalties that we need to worry about here or think about or consider. There's public performance royalties, mechanicals, and synchronization rights. Performance rights are a license fee paid out anytime someone plays your music publicly for commercial purposes. An example of this would be if you own a restaurant or if you own just a random shop and you're playing background music there. The music is being played for the benefit of your business, to entice your customers to stick around and shop or dine more, things like that. And performance royalties need to be paid out for that. So if you own a restaurant and you're just playing your personal Spotify, you're actually violating the terms of use. Yes.
I'll stop you for one moment.
Yeah.
I think there's an issue with, because I think you're going and the chat is saying the thing isn't progressing. I know you said that you were tracking it on your own in terms of the presentation, but we're still on slide 5 as it relates. And so, did you? Because you're on royalties.
If that's the case, would someone else mind controlling it for me? I'm on slide 15. I didn't realize that.
Let me see. You're on slide 15. Okay.
And I guess this is a good time. Are there any questions? Sorry, I was just trying to rush through so we can get to questions later. There's a lot to cover here, but let's take a pause. If there's any questions, I'm happy to answer.
Do you want? I was under the impression that you had control over the PowerPoint, and that's why I started moving it, because I noticed that it wasn't. But if you don't have, I can do it on mine. I didn't get a chance to review this in advance, so I don't know which slide is when to put the slide.
No worries. I think there's some kind of technical issue here, because on my side it looks like I can change the slides, but it sounds like they're not actually being changed. So yeah.
Correct. Okay, so let's just do that. I'll just control it moving forward.
Perfect. Thank you. And apologies for that. I didn't realize. I'm glad we caught it now.
Okay.
Salvage. Hold on. The question that I'm getting right now is, can you remark again on copyright for lyrics, or we have time for Q&A?
We'll have time for Q&A, but there's a separate copyright for the lyrics and the underlying music, like what would be written on what could be written in print versus the actual audible sound recording that was created in the studio. There's two separate copyrights, and so it's different rights flow from each. We can discuss that more a little bit later as well.
All right, and so next question. Will this slab be provided to attendees? Yes. I have a written piece that will be performed for live stream are you saying that I need an additional copyright? And this is from Jico Townsend.
You don't need. I guess the question is, has it already been recorded before?
And so I'll wait for her response. No, is the response.
Okay, so how about this? Let's get into live streaming in a little bit because we'll talk about the different copyrights that are necessary.
I'll let you look back into the presentation and then we'll bring in more questions later.
Cool, that's perfect.
I will start a queue so that everybody can have order, and I will just announce. Okay.
All right, sounds good. And I think we're starting to get a little behind considering the questions. Patrick, could you forward? Let's skip past this too. We can skip. Okay, cool. So a mechanical royalty is a second type of royalty that's paid out, and it's also known as a compulsory license. And it's a royalty that's paid when your song is reproduced. So that sound recording, that actual recording, when that's reproduced, you get a special royalty just for that. And we can go to the next slide. Synchronization rights are, again, when the music is synchronized to some kind of visual output. And it plays in film, TV, video ads, video games, movie trailers, anything that is a video. And we'll touch on in a little bit how it can apply to live streaming and how it sometimes does not apply to live streaming. We can go next. Samples are very important. And we're going to touch on why they're going to be important later. But the process for using a sample in your music is that you need to get sample clearance for it. So a sample is taking any sound and incorporating it into your own work. And usually it plays in by taking someone else's sound recording, someone else's music, and bringing it into your music. And whether it's EDM, hip hop, what have you, samples are used pervasively throughout the industry. And if you're using someone else's work, you are using their sound recording and their underlying musical composition, and you need to get permission from them to use that sample in your music. And the process of getting that sample is called a sample clearance. And you don't really need a sample if you're just using it in your own house or you're using it in a live show at a venue because the venue is already paying for those licenses. But otherwise, if you're recording it or streaming it, you need to get a sample clearance, which is permission. And if it's for recording, usually what you need to get is a copy, a permission from the owner of the master and the underlying musical composition. And you need to pay for that. And usually the way that payment structure works is they want royalties and possibly in advance. A replay is where you just create the sound again yourself. So in that case, you only need to get clearance from and pay the owner of the underlying musical composition and not the sound recording because you're not using the sound recording there. We can go to the next one. We can go next again. Okay, so I do want to touch on fair use really quickly because a lot of people have, I would say, a misunderstanding of what it is. What I hear from a lot of people is that they think fair use is a rule that allows you to use someone else's work. And people, incorporate that by saying, oh, as long as it's under 2 minutes of someone else's film, I can put it in my film. Or as long as I give them credit or a shout out, that's okay. So I just want to let everyone know that that's not actually what fair use is. Fair use is a defense against a claim of copyright infringement. So really fair use is something you only use once you've already been sued, once you're already in court, and once you're already incurring legal fees that you don't want to incur. Fair use isn't a rule that just allows you to use someone else's work. It's a defense that you use when it's already too late. Just to break down how fair use works is it's a 4-factor test. And it's kind of like the judge would take a totality of all 4 of the factors and put it together to determine whether or not fair use is a defense that applies for you so that you don't have to pay for having committed copyright infringement. The first factor is, what is the purpose and character of the use? So if you're trying to make money off of it in any way whatsoever, it's probably not fair use. If you're using it for nonprofit education, then it might well be fair use. It's kind of a spectrum. And when you're on one side, it's not good. And on the other side, it's more viable that you'll be able to claim fair use. Next is the nature of the copyrighted work. If you're quoting fact, you don't really need to worry too much because that's not going to be protected. Whereas if it's fiction, that would be protected. That is someone's original work of authorship, and that would be protected. So that would be less likely a situation where you could use fair use. The amount of substantiality of the portion used is also very, very important. Kind of like that if you just use 2 minutes, but really more about whether you're using the heart of the work. You know, if you're quoting Hamlet and you're using that to be or not to be section, that might actually go to the heart of the work because it goes to his mental state and his thought process on existence, right? Next is the effect on the potential market for the value of the copyrighted work. Are you possibly taking away money and listens from the original copyright owner? If so, there's an issue. If not, you might be okay to use fair use. But again, the overall idea is I would just suggest everyone not rely on the concept of fair use in using other people's copyrighted work. We can go to the next slide. Okay. Can I just get a pause on how many questions we might have right now?
Two questions right now, one from Sage Salvo and another from Stephanie Jones.
Okay, let's go through them real quick.
Okay, so Stephanie Jones asks what licenses are required for streaming.
Okay.
I'm about to get into that now.
Yeah, let's get into that.
So, and then Sage Salvo asks in regard to your last comment, what he's asking is can for-profit education also, or does the Fair Act apply to them in the same way? Fair use, I'm sorry.
Yeah, so the Fair Use Act would not apply to for-profit education the same way it does for nonprofit education because, again, they're trying to make money. But usually you don't have to worry too much about something like that. It really comes down to what you're doing and how you're doing it. But, you know, if you're creating a new online platform and you're using someone else's copyrighted work for for-profit education, that would be problematic. If you're in a middle school and you're playing a clip of someone's song so that the class can debate the nature of it, let's say a Jay-Z song where he's talking about getting pulled over in his Fourth Amendment rights as a discussion of Fourth Amendment rights, then you don't really need to worry so much. Jay-Z is probably not going to sue you, and neither are any of the other copyright owners. And B, it probably falls into fair use because you're using it for education and commentary and just learning. Does that answer the question?
Yes, sir.
All right, perfect. So let's pop into live streaming now. Sorry, you got something else, Timon?
Go ahead, Counselor.
All right, cool. Okay, so what is live streaming? It's the broadcasting of live video to an audience over the internet. It can be split up into two different ways. One is actually live and the other is not. The first is where you're actually live streaming, say on Facebook Live, something like that, as things happen. The second is a pre-recorded video that you're casting out as live content. And legally speaking, they're very different. You have, incentive to do pre-recorded in terms of, handling technical issues and making sure you're saying exactly what you want and things of that nature. But at the same time, there are a lot of negatives in terms of how pre-recorded video is treated. And we're going to get into that momentarily. So what do you need to proceed with live streaming? You need a platform. You need permissions for public performance rights and synchronization rights. And you also ideally need an audience. We can go next slide. So COVID has made live streaming extremely popular, and it's played out in a lot of different ways. And I've touched on 4 of the biggest ones here in terms of, I guess, different niche areas. So the first is BTS. BTS had their Bang Bang Con last year. They sold 750,000 tickets for roughly $20 million. I want to say it was a 3-day event, and they just played their own music. So for them, they created their own concert tour effectively and created the monies for their concert tour through their really dedicated and loyal fan base. For them, live streaming was a magnificent event that they were able to use in their own way to kind of bring back their lost income from touring and keep their fans engaged. It was a massive event and kind of broke a lot of records in terms of what and how it did. Next is Travis Scott's astronomical concert on Fortnite. Here he held a concert inside of a video game, in a video game platform. There were 27.7 million unique participants, and I want to say there were almost 50 million people that entered over the course of the 3-day event. It kind of broke paradigms in a lot of ways in terms of how a concert could be held. Now it's not just a regular live stream. It's in the guise of a video game where video game participants are able to, enter and witness and experience this concert in a brand new manner. Obviously, that's not going to be open to everyone. There's not that many Travis Scotts in the world, and there's not that many Fortnites in the world. But it created it really pushed boundaries of what is feasible in the live stream space. Next is Diplo. Diplo has his own label, his own setup, and he's, been around for quite a while. And what he did this round is he had a press release saying that all the artists would be paid for their music used. And for those that are not aware, Diplo is a DJ who works in a variety of spaces, including Moombahton and things like that. And he obviously samples a lot of people's work. And what he said is that he would make sure that all the artists would be paid for their music. He then put those sets on YouTube and in the metadata, put all the artist data so that YouTube royalties and revenue would go directly to the artists. So it's kind of like an idealized setup of how it should be. And Diplo, as an artist himself, made it happen. Next is D-Nice's Homeschool on Instagram Live. This was a very large and popular set that went viral, and it had everyone in the country or in the world, it seemed, was tuning into D-Nice's Homeschool, including the Obamas. And what it did is it created a lot of misunderstanding in the live stream space. D-Nice is a DJ, and he sampled a ton of other people's work, and he did it live. So it kind of gave everyone the impression that they could also DJ live on Instagram using other people's work and handle it in the same way. But it was very misleading because D-Nice, I don't know this for a fact, but I can pretty much guarantee it, is that D-Nice submitted his set list to Instagram beforehand, and the lawyers at Instagram went ahead and negotiated all the licenses necessary. So even though it looked like he was just spinning live, most likely royalties were negotiated with all copyright owners beforehand, which is not the same for a DJ that might be listening here that wants to put their own new set on Instagram Live, sampling someone else's work. So let's get into this a little bit more. Can we do the next slide, please? So there are a variety of different streaming platforms out there. There's free ones like Instagram and Facebook Live, Zoom and Google Hangouts, and Instagram Live and Facebook Live, I believe, have donation options available. Then there's free to play where viewers can contribute, and those are platforms like Twitch, YouNow, Caffeine, Periscope, etc. Then there's ticketed and paywalled sites. Those get a little bit more complicated, and usually you want a larger audience base there so that you can make sure you can handle the payment for use of this service. And now we're starting to get into VR space as well, and you'll see here a few different streaming platforms for VR. This list is not exhaustive. There are plenty more options out there. It's just a handful of the larger ones. We can go to the next slide. First things first, you want to be aware of the terms of service for each of these platforms. When you sign up on all, I just saw a question, what's VR? VR is virtual reality. It's kind of those big goggles that exist now and that have been in movies for the past 20 years. Terms of service are a contractual agreement. And anytime you download an app or anything like that, you agree to the terms of service. And one of the things you're doing is you are agreeing to license to all of these platforms a variety of things, like the right to use your own likeness. When you have your own image when you post your picture to Instagram, Instagram needs a license to be able to push that image out and for people to be able to search for it. So you have given them a license to use your own image. You've also promised them in these terms of use that anything you're uploaded, you have the rights to. And if you don't have the rights, you've also promised that you'll pay their legal costs. So if I upload a Jay-Z song to some YouTube platform or some platform and I don't have the rights to do that, and that platform gets sued, that platform can then come back to me and say, well, you uploaded it, you promised to indemnify us, and you're going to pay all of our legal costs. We can do the next slide. So YouTube, you know what, let's go ahead and pause for questions real quick.
So Shayna Lim asked, how do you find where to ask for sample request? I want to sample 4 seconds of a bass instrument and 1 verbal line of a hook.
Okay, so to get a sample clearance, you need to go to 2 different parties. You need to go to the owner of the sound recording and the owner of the musical composition. So you can search for this in all kinds of places. You can go to Sound Exchange, you can go to Harry Fox, and you can try and find out who the sound recording owner is. Whoever the label is likely is the sound recording owner there if it's a big enough song. That said, if it's 4 seconds of a bass line, it's small enough that you might be okay. Now, if it's a very important 4 seconds, like a very recognizable 4 seconds, then you want to be a little bit more careful. The most relevant case to this recently is the blurred lines case. And the blurred lines case really changed a lot of the laws around what's going on. For those that aren't familiar, Blurred Lines was a Robin Thicke and Pharrell Williams song where they sampled, or maybe didn't sample, whoever you want to believe. But basically the underlying sound for that song is very, very similar to a Marvin Gaye song. And what the jury and what the court said is that it was so similar that even though they're different songs and even though it was just one bass song sound pulled in, it was so similar that it kind of took away the market a little bit and it fell as copyright infringement. And so Pharrell and Robin Thicke had to pay the Marvin Gaye estate for use of this song. So coming back to it, what it comes down to is the question, and you have to ask this to yourself, is will your song sound very similar to their song? Is that 4 second bit that you're taking so similar that it's going to be instantly recognizable? And if it is, then you're going to want sample clearance. If it's not, you might be okay. What I would suggest for sections that are that short is doing what a lot of EDM producers and DJs do, and actually purchasing licenses to beats from online platforms. That's something you can absolutely do, and when you purchase that license, you have the ability to use it without having to seek out the owners of an existing song that you want to use.
Okay. And the next question that I have is from AM. It's popping up as, how do you get permission to use video that someone posts on YouTube or IG and no music is used?
You need to get written permission. Now, what I would say is there's a distinction here between platforms that are built on sharing and platforms that are not, and also cross-sharing between platforms. So TikTok, for example, is a platform built on pushing other people's video, especially with the duets and things like that. That is built into their terms of use, and it's a core function of what that platform does. So if you're on TikTok and doing a duet with them, you don't need to proactively get their permission for it. But if you wanted to take a TikTok video of someone else and put it on YouTube, that's moving to a different platform. That's going outside of the terms of service and the internal contractual arrangements, and that's going to require permission. For YouTube as well, you want to get written permission from someone, and that means just reaching out to the owner of the video. Fortunately, that's pretty easy to track these days, and you should be able to message that person and get written permission from them. Usually you want an actual contract for things like this, but it comes down to what your use is, how you're using it, and whether you'll be making money. If you're making money, there may be much more of a contract involved because that person will probably want either some kind of royalty cut or they'll want some kind of flat fee. And if you're not making money, maybe it's just, friendly on the internet usage. But again, written permission.
Okay, and I have from Devin Walker. So one, are you familiar with Live 365, which allows you to create your own public radio station? And also, has there been any issues of people using other people's music on their stations? They seem to pay royalties for songs on major labels, but not independent artists.
So I'm not super familiar with that, but just based on, what it sounds like is happening is in that case, if you're allowed to make your own station, they already have all the licenses in place. They'll be playing the mechanical royalties and the performance royalties to the extent they exist. So if they're paying royalties, I would say don't worry about it. The reason that they won't be paying independents as much is because of how royalties are calculated and tracked. There's a lot of music moving throughout the world at this point, and it's very difficult for everyone to track every single song. And it always has been. Back, in the 70s when it was just radio, no one could listen to every single radio station to track every single song played on every station in the country at all times. So what everybody used is what was called analogies. So there was a lot of self-reporting tied to some good faith efforts to track. So let's say there's 100 radio stations. Maybe the PROs, the performing rights organizations, listened to 2 of them. And they grabbed all of the music, they created a little matrix of how much each song was used proportionally, and they analogized that to everybody else. So the way the system works is it's really tilted to the big names. Performance like Drake or Rihanna, and that's because it's easy to track how many times their songs are played, and it's easy to just give them a proportion. But for independents, it's really hard to track how many times each song is played proportionally, so a lot of times they get left out of that spectrum of royalties, and they don't get paid as much. That said, the way around that is if you are the independent and you are, playing it on a radio station, you can submit your set list to a PRO. And the same thing when it comes to a live venue. If you're an independent artist, when you play a live venue, you're playing your own songs, you want to submit your set list to the PRO so that your name comes into that mix, so that your name starts getting tracked.
Okay, and the next question that I have up for you, kind sir, is how are royalties tracked for sync, and can a sound be tracked if the IRSC isn't embedded?
Okay, so let's talk about syncs right now. So syncs are different from performance royalties and from mechanicals in the sense that there is no compulsory license, which means that syncs have to be negotiated each and every time with both copyright owners. And we touched this a little bit earlier, but if you do, let's say you want to create a video of yourself with somebody else's sound recording. In that case, you're using both copyrights. And you need to get permission and pay fees to both copyright owners, the sound recording owner and the underlying musical composition owner. And you'll negotiate with both of these parties independently, but usually what happens is you negotiate with the publisher first, and then it'll be the exact same fee that's accepted by the record label. And depending on what your use is and how you use it, that fee can range drastically. If you are making a a Marvel film and you want that song to be the intro to the movie and also use in advertising, you might be paying $1 million for it. If you're using a Kendrick Lamar song, he might want $1 million for it. At the same time, if you're making an independent film and you're not really planning on theatrical releases, just using it at festivals, you might be able to get that same song off Kendrick Lamar for like $2,500. In each case, whatever the song is, you're going to have to negotiate it each time you want to use it. And anytime, again, the song is paired with video and tied together, that license is necessary. Now, it's different if you're the owner. If you're the owner of the copyright, then you don't need to worry about it. If you created the song yourself and recorded the song yourself, and then you're putting that video online anywhere, using it in a movie, well, it's your song. So you don't have to pay yourself. You don't need to negotiate anything. It comes down to when you use somebody else's music. That said, quick caveat, if it is your own music and you are, working with a record label because you're an established artist and you have a publisher, your recording agreement might have limitations in how you can use your own music. So you should be wary of that. Even if you're, let's go back to Kendrick Lamar. If you're Kendrick Lamar, you're working with a label. The label controls your music. They have the ownership of the copyright of the music. So that doesn't mean that Kendrick can just go out and stream his own music live. He may well need to get permission from his label before he can do that. Any other questions, Tita?
No, that is the rest of the questions, I believe, Cancer.
Cool. I believe we missed one. I didn't answer one of them, and it was tied to the ISRC. So ISRC is part of metadata. The metadata kind of defines who the owner is, who the publisher is, who the artist is, who the songwriter is, and where all the royalties get paid. And anytime you upload music or videos or anything like that anywhere, you should have your metadata carefully filled out because it determines whether or not you'll get paid and whether or not other people get paid. So all the different platforms create content in different ways because they have their own proprietary systems or sometimes they don't. For YouTube, that system is called Content ID. It's their internal identification technology, and I would say consider it like AI. It just scans audio content within a video and matches it with their internal library to reference whether or not you might be using someone else's work. If you are, in some cases, it'll pay out copyrights to those owners from the ad revenue from the video. In other cases, it will block your video because it will say, well, you do not have rights to this content. The way Content ID works really is that they supply the PROs or the intermediaries for performing rights organizations with usage reports. And that is then given to the PROs, and then when YouTube pays out royalties, it pays out the royalties along with the usage reports so that the PROs know who to pay and how. Next slide, please.
We have one more question if we have time for you to answer one more question before you move on from Monica Bowes. What are my rights if I put my artwork and video out in a video live stream, say Facebook or Instagram?
She said, what are my rights?
Yeah, what are her rights if she puts her artwork and video out in a video live stream on Facebook or IG? So I guess what are her rights and what can she claim as, it is her artwork?
What kind of artwork are we talking about?
And it says how does it affect my copyright or her copyright?
Okay. Are we talking about music? Are we talking about
artwork, visual arts?
Okay, so what I would say is that it doesn't really affect your copyright, at least from where I'm sitting. It doesn't really affect your copyright. What I would say, though, is that you might want to register your copyright first, just so that the world is on notice that you have a copyright in this work as of this specific day. It can take a lot of time for a copyright office to go through the process, and what they've said recently is that the date of your copyright instills on when they approve it, not when you submit it. So often it'll be in your interest to register it early and then wait a little while to start posting it everywhere. But in the end, like I said before, you have that instant copyright anyway. So I will always suggest you register your work, especially considering that it's like $35. It's very little, relatively speaking, for the protections that you get. So I would register the copyright first and then do what you want with it. It will be on you to make sure that other people don't use it. So let's say you live stream something with your work and then somebody else copies it and then starts selling it. It's on you to enforce it. But if you have registered the copyright already, it's much easier to prove infringement and also much easier to get them to pay for all of your costs and all of your legal fees. Obviously, no one wants to go to court in this matter. Usually that's a worst case scenario. But overall, I would say I strongly suggest registering it first. And as soon as you've registered it for visual art, go ahead and push it out. Market it, do whatever you want with it. Live stream with it, show it off, and bring it to the world.
Go ahead.
Okay. Facebook and Instagram have a variety of licensing agreements in place which are confidential. They don't supply PROs with their own data. And again, they pay out royalties using analogies, which is that whole, this is probably what the proportion is based on our surveys. And so this is what we're going to pay. And this is why independents don't get their share. We can go to the next slide. We can move on as well. Actually, you know what? Sorry, let's stay there. Just real quick, this is directly from Facebook and Instagram in terms of how you can use music in your live streams. They say music and stories and traditional live music performances, like filming an artist or band performing, are permitted. What they say is the greater the number of full-length tracks recorded in your video, the more likely it'll be shut down. And for that reason, they recommend shorter clips. So they have some licenses in place, but they're not transparent about what those licenses are, who those licenses are with, or what those licenses cover. So what they suggest is if you're sampling something, keep it short. The person that suggested 4 seconds, that might be okay here unless that 4 seconds is looping continuously. If you're using 10 or 12 seconds, maybe that's okay. But if you're using half a Biggie track, that's probably not going to fly, and Instagram would shut you down, or at least give you that notice that they're about to shut you down unless you change that song. They also say there always needs to be a visual component to your video, and it can't just be promoting that audio work. We can do next slide. So Twitch is one of the largest growing platforms for music during COVID, and a lot of people have been moving over there because they think everything's clear. I just want to give you guys a heads up that it's not. In 1 week in June last year, they got 2,500 DMCA takedown notices. And that's pretty significant. They started using Audible Magic to search user-generated content and shut it down themselves, but it's far from perfect. What I want to specify here is that they have agreements in place with PROs, but not with labels. That means they have agreements for a lot of the songwriters. So if you want to recreate the music yourself, that's okay. But if you want to just play someone else's music, that's problematic on Twitch, and I would not suggest it. We can go to the next slide. Here's a little bit of a breakdown from Twitch on how you can use music and how you can't. Are there any questions? We got 1 minute left, so I think we're behind here, but I want to.
Yeah. So we are closing in on time, and I want to be respectful of everybody and everybody's day. So I'll give you the next question, and it says, what if I sing a song written by someone else and put it on Facebook?
So for something like that, you're creating a cover. If it's something recorded, there would absolutely be mechanical. Now, if it's just live, then it would just be performance royalties, and that might be covered by their existing licenses. But if you're holding that, then there's a mechanical license due, and we just don't know if Facebook and Instagram do that. So I would say it's in your interest to get permission from the rights holder, and you can do that through Harry Fox, and try and get that license from them, the mechanical license, the compulsory license. And you may need to get a sync license from the owner as well. Search Sound Exchange, and you can probably find the publisher or the song underlying musical composition copyright owner, and you would want to negotiate with them for that. Otherwise, it could be taken down because you have not paid the sync license.
Okay. And out of respect for you, kind sir, Mr. Hardeep, do you have any last words before we transition to let everybody go on about their day?
Yeah, absolutely. I would say if you're live streaming music, live stream your own music. That's going to be the safest. If you're trying to live stream other people's music, including as a DJ, that can get really problematic really quick. Most likely the platforms will just shut you down. That's your best case scenario. Your worst case scenario is if you actually get sued by someone. So just be wary of doing something like that. Also, big shout out to DC Commission on Arts and Humanities for doing something like this. This is a great program, and I'm glad that this resource is available for everyone. And again, just to chime in on what Vance was saying earlier, WALA is a great organization for artists. Membership is pretty cheap, and you get great benefits, including a lot of classes. So just shout out to WALA for that, and everyone stay safe.
Okay. And so with that being said, I want to thank you, kind sir. I want to acknowledge our director, Haran, who has joined us on the call. I want to say thank you to her for the opportunity and putting this together for people as we're trying to help people navigate the unprecedented times that COVID has created. And so with that being said, if you want to look in the chat, I put a link below for the Tele Town Hall that we will be having tomorrow on January the 28th. If you go to our website, DCArts at dc.gov, DCArts.dc.gov. I'm sorry, people. But if you go there on the front page, you'll also see a link that will get you to that registration. Just as also another reminder, our 2021 Facilities and Buildings Grant deadline will be coming up on the 29th. So I just want to say last words. Thank everybody for also joining us, for being great participants. And so with that being said, everybody enjoy your day. Oh, quick to answer the question. Yes, we will be providing the recording of this video on our website, which is dcarts.dc.gov as well, so that everybody can watch this. So again, thank you for everybody. Thank you, Hardeep, for participating and doing this with us, and enjoy your day. Be safe, and everybody stay COVID free, and we will see you next time. Thank you.